Welcome to Texas Probate Made Simple under the KISS principle.
Welcome back to Texas Probate Made Simple under the KISS principle. Riley Hetherington is a board-certified attorney serving Harris County and surrounding Texas counties. His practice is focused on guiding families through probate and estate planning with clarity, compassion, and confidence. I'm Heidi Mack, and today we're going to be talking how to step in to help parents with estate planning. Thank you for joining us again, Riley. We appreciate you being here.
Good to see you, Heidi.
Thank you. Thank you. Well, let's get right into this, Riley, here. Families often do wait until there's a health scare before talking about planning. Why does waiting make things harder?
Well, when you wait until there is a health scare or a health problem, there's serious issues. Quite often you have diminished physical capacity, possibly diminished mental capacity, and you're much more susceptible at that point in time to making wrong decisions, to be under the influence of folks that may not have your best interest in mind. And later on, could result in claims being made that you did not have the capacity to sign any documents or make any decisions during that time period. So you want to try to do all estate planning type matters when you're in as good a health as possible, and when you definitely are and have the mental acuity to be able to make decisions.
And, I think this happens to a lot of families. How do you suggest children then? How do they respond to a parent that might be like brushing it off, like, brushing the topic off by saying they'll deal with it later?
I always find that relating personal experiences to the person who really don't think it's important can be very effective. For instance, if the best friend of the parent has just had problems either prior to or after one of the partners has passed away, that's a good way to start talking about, hey, you realize that your best friend just went through this. His spouse is paying all kinds of additional fees and can't make decisions, all of which could have been avoided, mom and dad, if you would just sit down now and start going through things and making some decisions when you're in good shape to do so. So quite often that has a good way of kind of breaking through the ice as far as when they say, I don't think this will apply to me.
Well, then, so when we're talking about planning and such, what are those things that can cause like maybe the most stress when for a family when it's not been planned yet, like when there's no plan in place?
Well, a couple things. If it's prior to the time you die, and even after the death of one of the parties, there's serious issues with respect to asset location and management and where everything is. If it's during the person's lifetime, medical decisions and physical location are tremendous decisions that have to be made, sometimes without the consent or even over the consent of the person who's involved. All that's avoided if you've allowed that person and the person has taken steps prior to the time that he or she reaches a point like that to make those decisions. So again, early planning is very important, and more importantly is the implementation of that early planning.
Riley, I'm assuming you have a lot of stories. So, is there one that you could share with us that where you helped them early plan, which saved their family a lot of strife?
Yes, I can. As a matter of fact, I had a client who, for many, many years, received very, very small amounts of money off some oil and gas leases in West Texas. Uh, really didn't think much about it. And then all of a sudden, she called me one day and she said, well, I got $1,500 last year on all of the oil and gas leases in West Texas. I've just received a check for $100,000 for just this month. That was the big oil play that occurred about 15 years ago in West Texas, and people became very wealthy very quickly. Well, she had five children, and she knew at that point in time that there was never going to be agreement with the five kids as to how to handle matters, since there was such a much larger estate that was going to be involved. So we set up trust instruments for her. She made the decisions as to who would manage those properties and how those properties would be dealt with after death, extending those benefits all the way down to grandchildren. And so that's an example of someone realized that there was going to be an issue. She had already been diagnosed with some cancer at that point in time, so she knew that life can end at any time and the future is uncertain. And she made those decisions, and it really, really, really worked out for the best benefits of everyone concerned and cut down on the enormous amount of potential fighting and issues over what ended up being a considerable estate. So that's a pretty good example of what can be saved as far as anguish and litigation in some cases, and certainly fights among the folks over substantial amounts of money.
Well, you were talking about siblings there. Say, like, and you said that you're worried about it not being like on the same page. Was there, like, even in that situation, a constructive way to approach that situation?
She did, and I can tell you that what we did in that case is we put together the plan, and obviously after numerous communications with her, reduced it to writing. And then we shared all of that information, including the exact documents that were going to be signed, to all of the children, and invited the children to comment, ask questions, etc. After that had been done, she decided that she would have a family meeting and invite everyone to come to that family meeting. So if there were any questions in person, they could ask them then. And that's exactly what happened. And you could tell at the family meeting that there were going to be issues if she did not implement a constructive and fully competent plan. But it was all avoided because they had to meet face to face. They got their chance to ask the questions then. They heard from her verbally and conclusively what her desires were. And so when she, in fact, did pass away about 12 months later, it was so much easier and better for everyone. And it went so much smoother. A couple of things happened in that regard. Mainly, it helped the family to stay together and not be corrosive or combative. And secondly, everyone knew how the assets would be transferred. They were treated equally, they were benefited by it. And so it really, really did a lot to keep the family together. And I have always admired her so much for taking those steps and for making it so transparent with respect to all the family members. That's the only way to do it. If you don't do it that way, there's always going to be issues, even if you do very good planning.
I mean, honestly, hearing that, I mean, if somebody doesn't come to you early, I don't know what they're doing because you know what you're talking about. And that sounded like, even in that type of situation, it sounded like, you helped alleviate some high emotions that can definitely come with this. So, when you're talking to newer clients, then is there some, like, what is that small, non intimidating way to start? The simple steps so it doesn't feel overwhelming.
I have a, 5-page straightforward form that I always send to clients uh, when we get started. And it handles them to be able to list in summary fashion the assets that they have, insurance policies, major debts, mortgages, et cetera, that they have in very summary form. That form can be the basis for all the questioning and communications that subsequently take place as we flesh out the plan and get everything in place for them to sign documents that will obviously take care of them, hopefully during their lifetime, as far as important aspects, as well as after one of them passes away. So I always find that's a good way and a non-intimidating way of doing it. And then after I send it out, sometimes I get it back, sometimes I don't, and sometimes I will call them and I say, "Look, if you've got 10 minutes, I'll go through the list myself and make notes, and then we can set up a time for us to further talk about that." So it's a good way and a very non-intimidating way to start the process.
Yeah, I would like that paper as well. I'm like, I'm a more visual person that would make something like that definitely less intimidating. Well, say you're dealing then with clients that already do have stuff already prepared, and say, these children are seeing this paperwork. Do they when do they need to look at it? well, that it might be outdated? Is there a time frame of some sort?
Well, as everybody knows, life is a constant move forward, and things change and can change on a dime. Obviously, if you have children listed in your documents and they have now reached the age of 18 and are of majority, or they get divorced, or if the parties get divorced, if there is sickness and illness that a party is going through, or if a diagnosis has been made that they're possibly going to need treatment. And I always say, after a period of 3 years between the time you last looked at your documents, any of those types of transactions or events should trigger you to really review the documents. And so what I tell my clients is just keep a copy of the documents. They're on your computer or in hard copy near where you look at papers and pay bills and that kind of thing and conduct your business at home, and pull it out from time to time. We also try to have a system to try to remind folks, especially if there have been major changes in tax laws and that kind of thing, that will let them know that the law firm is staying on top of what's going on in that world. And so all of those are ways that you really should keep the documents up to date. Additionally, people think that these documents are written in stone. They are not. They are revocable in most cases and can be altered, changed, or updated at any point in time. And so I always encourage to people that, yes, you've spent your initial amount of money, you've gone to the lawyer and CPA, et cetera, but it's not something that's a one-time deal. It needs to be looked at on a continuing basis.
I will say from experience, it's been a while since I've lost my father, but he was always very diligent about that, and uh, I always had all the paperwork. And if he felt like something was changed, he always gave me something new. So when that time came, I was able to get take care of everything very quickly as best as possible because he was on top of that. So, when you do work with your clients, then how do you encourage these families to balance being respectful with making sure the legal essentials are actually being handled then?
Well, as I've indicated in some previous sessions that we've had, I really like for my clients to have control of their life and their life decisions. And it's my task to try to assist them in making decisions so that they can make them on their own and feel like that they have actually handled matters in a very reasonable manner. And it's interesting that you talk about your dad, and I can tell you you're very fortunate he had that as a habit and as part of his personality, because it makes your efforts and the stress that you probably went through once he passed away, the mere fact that you lost him was enough to cause you tremendous stress. And had he not done that, he would not have had control of the situation. He would not have had control of being able to assist you in your grief time and period, and things would have been overlooked. So it's very important that that balance always exists between the control that the person has over their own life and decisions and the control over how they can minimize the amount of stress and the amount of grief that everyone goes through when they're no longer around.
Well, Riley, as we're starting to finish up this episode, I really appreciate your kind words there. And, for the listeners out there, they're worried about bringing this up with their own parents. What is the most important takeaway from today's conversation?
Well, I think as a child, and I know with my own parents 30 plus years ago when they were making those decisions, uh, I related it to my own planning. I basically said, "Hey, I've been to a good partner friend of mine and doing my estate planning, and he brought up a bunch of issues with respect to how things would get passed to my surviving wife, and then on to the kids." And it really gives me a great deal of comfort knowing that I've got a plan in place, and I would really hope that you would make sure that you do also, because again, those are matters that are yours to decide, and it would definitely do nothing but cause us great deal of comfort knowing that those decisions had been made, that you had appointed who you wanted to appoint to take over certain duties, and it was all done at a time before you got sick. And in fact, my parents did decide that on a personal level about 3 years before each of them died. They had been married for 50 plus years. They died within a year of each other from two different types of cancer. But they made those decisions at a time when they were in relatively good health, definitely were very cognizant about what was going on, and they really appreciated it as they did begin to go through the final phases of life, that all of that had been taken care of. So I always try to relate it to my own personal experience, and I recommend to children that they do the same when they approach their parents.
Well, thank you so much, Riley. And that is it for today's episode of the Texas Probate Made Simple under the KISS principle. If your family needs guidance with probate or estate planning, visit hetheringtonlaw.com to connect with Riley. And as always, don't forget to like, subscribe, and leave a review if you found today's episode helpful. Thank you so much, Riley, for your information. As always, we really appreciate it.
Thank you, Heidi.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.